All rise. Veuillez vous lever. Veuillez vous asseoir.
Mr. Yena, you still have the floor. Microphone, please. Microphone, please. It only happens at the beginning, always, Mr. Yena.
I hope it does. Thank you. Mr. President and Your Honors, it needs no reminder that this is a court of justice and not a court of political convenience, where states that find themselves inextricably interwoven in the very mess they have created run to it to clean their mess. While we do fully associate ourselves with the fact that not only the victims of the violence in northern Uganda, but the entire world has waited for far too long for justice for the people of northern Uganda, it behooves this court to ensure that justice is not only done, but seen to be done to all and sundry. The people are hopeful to see fulfilled the legal adage that justice is no respecter of any person, however majestic. With the risk of being misunderstood, Mr. President and Your Honor, let it be stated here and now that justice in the situation in northern Uganda shall not be complete and shall not be seen to be done unless the leaders of the government of Uganda, particularly the UPDF commanders who devised and supervised the purported policies of countering the LRA, are arraigned before this court. Just like it has already been elicited from many prosecution witnesses, defense will bring witnesses to show that some, if not most, of the crimes the accused has been charged with could have been either committed by the UPDF or at their behest. The people of northern Uganda had hoped that all the key players in the theater of violence in northern Uganda would be before this court at the same time in order to enable the court to properly discern and appropriately apportion responsibility to the perpetrators. Sometimes one is left to wonder whether the saying that when a coward sees a weakling, he feels hungry for a fight is holding good in this case. Is the accused before you that proverbial weakling in the theater of atrocities in northern Uganda? Are the UPDF commanders and the leadership of Uganda often accused of committing atrocities designedly, or designing policies that led to atrocities of genocidal proportions, the strong ones, the prosecution daren't touch? Defense is not here to condone impunity, Your Honors. Far from it. Defense is here to lead evidence to confirm that prosecution has miserably failed to adduce evidence to prove, or even to provide sufficient evidence to prove that the accused is responsible for any criminal act or omission which he has been charged with. Your Honors will have realized that the defense has not adduced any evidence to prove intent on the part, prosecution has not produced any evidence to prove intent on the part of the accused. The crimes are indeed against the LRA and its omnipotent leader, Joseph Kony, or his commanders, who may have assisted him in the formulation of the LRA policies long before the accused was abducted and conscripted into the LRA. Mr. President, and your honors, witnesses shall testify that the conflict in northern Uganda turned out to be a cash cow for the UPDF officers who went to great lengths to ensure that the conflict did not end. And I will want to show a short video at 34:40 to 35:10.
The war became a huge business in itself for commanders on the government side, because they had a lot of slush funds that were not accountable for as operation funds. Nobody could verify the strength, the number of soldiers who were there in the war because of the mobility and fluidity of the war.
Many of the general commanding officers there would claim, I have perhaps, 5,000 troops. And they had maybe 200. The rest were what you call ghost fighters.
When I carried out an investigation into ghost soldiers in 2003, we found that some battalions were 120 people, a battalion of 730. Some brigades like 305 had 3 people, a commander and his assistant. And yet it would take money for a brigade.
So you can see.
Your honors, that will go, Mr. President and your honors, that will go a long way into proving the motives behind the continued war in northern Uganda. Indeed, it will also show that some of the alleged crimes could scarcely have been committed by the accused. But Mr. President and your honors, let us now look at the LRA organizational, command structure, and operations to see whether the accused had a prominent place and had the opportunity to do what is accused of having been done, of him having done, especially the intent. Spiritualism in the LRA. Your honors, Joseph Kony claimed to be the Messiah sent by God to cleanse and transform society to turn to God and be ruled by the 10 Commandments. His mission was first and foremost to save the Acholi people from an evil and repressive NRM regime of Yoweri Museveni. He was to prepare an army of clean people who would overthrow Museveni's government and install a government based on the 10 Commandments. Therefore, the cleansing process started with the LRA soldiers themselves, who had to conform to the 10 Commandments, or as interpreted by Joseph Kony himself. Joseph Kony claimed to be a Messiah sent I think that what is covered. The LRA was woven around the mind-boggling indoctrination and unparalleled ruthlessness as a policy of exacting complete loyalty from its soldiers. The success of the mysticism with which it prosecuted the war and which gripped the abductees with awe and total submission was only justified, or shall we say, was facilitated by the sheer negligence and failure of the government of Uganda and the international community to summarily end the conflict or capture the leader of LRA, even with the intervention of the mightiest army in the world, the American army, after spending tens of billions of American taxpayers' money. Mr. President and Your Honors, LRA was and still is a spirit-based organization. A fairly elaborate detail of the LRA organization, operations, and structure is contained in a document compiled and edited by Lieutenant Colonel R.W. Score, Defense and Army Attaché, U.S. Embassy, Kampala, which is found in the document presented as defense document presented as UGA-D26-0022-001. Your Honors, from the reading of the above document and from what is known about Joseph Koin's spiritualism, it is clear that Joseph Koin was believed to have some supernatural powers. It was a mixed grill of Christian, Muslim, as well as traditional beliefs. According to the testimonies of some witnesses already on court record and evidence yet to be produced by the defense, LRA is an organization believed to belong to some metaphysical beings from the spirit world. Those ill-defined metaphysical beings used Joseph Koin as the medium through whom they controlled the affairs of LRA. Nevertheless, the ordinary mortal, to the ordinary mortal, LRA was a personal army of Joseph Koin, who used spiritual powers to control it. Quite often, Joseph Koin himself is stated to have told some people that the army was not his as a human person, but rather it belonged to the spirits that used him as their messenger. The spirits were stated to be 13 in number. Each of these chaired a different functional committee, according to evidence from that same document referred to. According to evidence available. Your Honors, these were stated to come from as far afield as the USA, China, Italy, Tanzania, and Uganda. Some among them were Joma Oris Aka Oriska Dibaho, who was the overall chairman of all the spirits. Sili Salindi Aka Malia Mackay, who is the chairperson in charge of operations. Then there was Who Are You, otherwise known as Zinc Bricky. This was a spirit from the USA, who was the chairman of intelligence operations. Then there was King Bruce, another spirit from the USA, who controlled heavy weapons. And last but not least, Your Honors, Willing Hingsu, a spirit from China, who was responsible for performing miracles which helped the LRA win battles. Mr. President, and Your Honors, it is clear from the above that Joseph Koin's powers were akin to witchcraft. Therefore, it will be necessary to refer Your Honors to the Ugandan Witchcraft Act to illustrate the impact of witchcraft on the minds of at least those who believed it. Section 2 of the Act recognizes and criminalizes use of witchcraft and supernatural powers, which is punishable by life imprisonment. And it provides, and I beg to quote, Mr. President and Your Honors, any person who directly or indirectly threatens another with death by witchcraft or by any other supernatural means commits an offense and is liable on conviction to life imprisonment. The second provision, Your Honor, is that any person who directly or indirectly threatens to cause disease or any physical harm to another, or to cause disease or harm to any livestock, or harm any other or by any other supernatural means commits an offense and is liable to conviction to imprisonment for a period not exceeding 10 years. Your Honors, the Witchcraft Act seems clearly to point out that witchcraft is akin to natural power, to supernatural power. This definition of witchcraft is supported by socio-anthropological writers like E. Evans Pritchard, who describes an act of witchcraft as a psychic act. And LaFontaine, in his essay on the Bagish tribe of Bugishu in Uganda, who defines witchcraft as all supernatural attacks. The Tanzanian statute, which Your Honors will also be referred to, is even on a better footing. Section 2 reads, witchcraft includes sorcery, enchantment, bewitching, the use of instruments of witchcraft, the purported exercise of any occult power, and the purported possession of any occult knowledge. Mr. President and Your Honors, we felt constrained to make reference to these to remind this court about the cultural belief of the society from which this case arises. It is important that Your Honors keep them in your mind when considering spiritualism in LRA, that the accused belongs to the Ugandan society, which recognizes the existence and threat of supernatural powers. It will therefore be easy to put into context how the accused could have been affected by the supernatural powers or belief in it, which Joseph Kony was believed to possess. Defense will also bring witnesses who practice or have practiced witchcraft in the past to give their testimonies about the presence and impact of supernatural powers on victims. Your Honors will remember some prosecution testimonies about the spiritual attributes of Joseph Kony. That included his prophecies, spell binding, combat operations, fighting against and defeating spirits, some of which were sent to assist the UPDF in their war efforts against the LRA, etc., etc. It will also be shown that this spiritual warfare was not confined to Joseph Kony alone. President Museveni himself is on record in Uganda as having said that when they were fighting guerrilla warfare in the bush, they used witchcraft. Mr. President and Your Honors, I now turn to the organization and command structure of the LRA. Your Honors will be reminded that many prosecution witnesses have already given useful information about the organizational, operational, and command structure of the LRA. Prosecution witnessed 205. Of course, we didn't have as many as 2005. A former LRA officer who worked under Dominic Ongwen and is currently with the UPDF testified that although LRA had appearances of a conventional army, nevertheless, it did not actually function as such. Witness P0070 stated that the LRA followed no strict chain of command like the UPDF. Witness P0142 stated that LRA brigades and battalions were grossly smaller than that of a conventional military. They clearly testified that in LRA, Joseph Coyne can issue an order directly to a battalion commander or in a rank, skipping over more senior commanders. This would not happen in a properly functioning conventional army. Joseph Coyne did not have to consult anybody on any matter. And if he didn't, however wrong it was not open to anybody to pose his orders. It will be up to you, to your honors, to consider whether, in those circumstances, the accused was an exception to this strict edict. Defense will lead evidence to show that while in the conventional army, the commander-in-chief consults the Army Council on whether or not to attack, in the LRA, Coyne instead issued orders allegedly from his erstwhile spirits without consulting anybody and without regard to rank and hierarchy. The orders were strict and unquestionable. It will be shown that Joseph Coyne used the pretext of being the spirit medium to control and direct all aspects of planning and operations of LRA war. It is therefore not true, as asserted by the prosecution, that the LRA is a disciplined, hierarchical, armed group with a formal rank structure mirroring that of a conventional army, and further that orders flowed down the chain of command and reports on operations were transmitted back up the chain of command. Defense will, however, bring witnesses who will re-emphasize the prosecution evidence that discipline in the LRA was strict and punishment of infractions of the rules were brutal. Attempts to escape, especially, were particularly harshly dealt with. Those who were caught were either put to death or caned so severely that permanent injuries was usually caused. As a matter of fact, the structure and rank hierarchy in the LRA counted for nothing. Joseph Coyne was merely a copycat who wanted to show Museveni that what Museveni could do, he too could do. For instance, witnesses will be brought to testify that whenever Museveni promoted himself and his top commanders, Coyne replicated the same thing. When Museveni, for instance, promoted himself and the chief of his defense forces to the rank of lieutenant general and major general, respectively, Coyne also promoted himself and his second in command, the late Vincent T, to lieutenant general and major general, respectively. When Museveni made himself a general and his army commander a lieutenant general, Coyne too made himself a general and his second in command, lieutenant general. By the same token, When the highest operational unit of the UPDF was the brigade, Kony also made the highest operational unit of the LRA the brigade and put the late Tabule in charge. Later when the UPDF established divisions, Kony also did the same and put the late Tabule in charge as the division commander. Defense shall bring witnesses to show in more graphic details, Your Honors, how Joseph Kony and his LRA used spiritualism to control the minds of the LRA soldiers. From the time of abduction, abductees were run through a raft of initiation ceremonies, which did not only include libations by use of the shea oil, but were cowered into total submission by infliction of excruciating pain through beatings and exposure to some of the most horrifying and gruesome torture and killings. Some of them were made to participate in these episodes themselves. Some were made to kill their own parents. And all these were alleged to be dictates for a cleansing process from the spirits. Your Honors, I shall now look at the prosecution case in outline. Mr. President and Your Honors, the evidential premise of the prosecution case, and that is what the prosecution calls the varieties from which their evidence come, are three. And these are, first, from accounts given by victims of the war. Secondly, from former LRA soldiers. And thirdly, but mainly on sound recordings and other allegedly reliable records of radio communication passing between the LRA commanders at the time these attacks took place. The prosecution has also accused Dominic Ongwen of playing a prominent role in the planning and execution of the charged attacks, first and foremost. As stated earlier, Dominic Ongwen, like others conscripted into the LRA, were clearly instructed and knew that their enemies were Yoweri Museveni and his UPDF and their allied forces. As such, Dominic Ongwen could not have heard the motive, let alone formed the intention of attacking a civilian population, which was not indicated to him as the enemies of LRA. It will be clear that LRA only engaged in attacks on UPDF soft targets to get military and other supplies from them, or in self-defense. The only LRA attack which involved civilians, especially the IDP camps, were not targeted at civilians per se. They were aimed to look for food out of necessity. And Your Honors, isn't it the saying that necessity obeys no law? Defense shall bring evidence to discredit the first two varieties of evidence. First of all, by the same token, the defense shall bring witnesses who were also victims to give different accounts, different and more credible accounts of events from those given by the victims of the war who testified as prosecution witnesses. Secondly, and particularly in the case of the attack on Abok and Lukodi. Defense will bring witnesses who participated in the counterattack as part of the government auxiliary forces to give a more credible account of what exactly happened and who they discern as having led the attacks. The third category of witnesses shall be victims who escaped from captivity and returned. Fourthly, we shall bring some community leaders, including some camp leaders, not only to give an account of what happened during the attacks, but also to show the organization, positioning, strength, and laxity of the UPDF around the IDP camps, which exposed the civilians in the camps to vulnerability. The same variety of witnesses shall also show that there was always exchange of gunfire between the LRA and the government soldiers. Therefore, in the absence of forensic analysis of the gunshot wounds, like has already been stated, it cannot be said with certainty whose gunshots killed the victims. Were they the LRA or government soldiers? And in respect to the intercepts, Mr. President and your honors, in the case of the third variety, some recordings are allegedly stated to be reliable records of radio communications passing between the LRA commanders at the time these attacks took place. First of all, defense will assiduously contest and take issue with the assertion of the prosecution that the interceptors were trained professionals. From records on the interceptors, it is clear that they were persons trained on the job. It will be shown that it takes more than a person who hardly possesses an ordinary level certificate who trains on the job to be a professional. Take P003, for example. He is a former child soldier of the UPDF who trained on the job. And apart from getting some certificate after a few months training, he did not prove any professional specialization after training from any accredited institution. Your honors will realize that it would be very unsafe to rely on supposedly expert evidence given by such a person. Secondly, your honors, the prosecution promised during the opening statement to submit radio communication intercepts and logbooks to prove Mr. Ongwen's participation in the attacks at the 4 charged crime locations. The prosecution claimed that these recordings show Mr. Ongwen's responsibility for Odek, Lukodi, and Abok, and that the logbooks contained recordings showing Ongwen's alleged participation in Pajule. To date, you will reckon your honors, the prosecution has not fulfilled their promise in that regard. They have not provided this to assist court. Can the court rely on secondary evidence when the primary evidence promised to be produced by the prosecution have deliberately been kept away? What inference can be drawn from their failure to deliver on their promise? The only reasonable inference as far as defense is concerned is that there is something to hide from the primary evidence. Mr. President and your honors, the defense will show that without the benefit of primary evidence, this court shall not be able to evaluate properly with certainty to decide, number one, whether or not the voice attribution in the tapes is indeed that of Dominic Ongwen. Many doubts persist and were not clarified by the OTP witnesses. For example, the defense highlighted during cross-examination items such as intelligence reports and logbook entries that indicate George Labon as taking responsibility for the charged attacks on a Bok or deck. The defense will also caution court about the safety of relying on the voice attribution made by prosecution witness number 16 and number 19, who did not create the audios and were not used to hearing voices on, on the recordings. It is also pertinent, Your Honors, to note that these witnesses had never met Dominic Ongwen in person or heard his voice to enable them to identify in the courtroom that the voice in the intercepts were indeed his. Mr. President and Your Honors, even more telling is the fact that these witnesses who purported to attribute the intercepted voice to Dominic Ongwen were not provided with copies of the alleged contemporaneous notes they made to enable them explain variations in the messages and diction in several areas of inaudible segments of the enhanced versions. The difficulties these witnesses had in listening in and explaining the enhanced copies mirrors the even greater difficulties they might have had recording the intercepts and transcribing contemporaneously in English, which was not the language in which the speakers communicated. In case the court is satisfied that the voice is that of Dominic Ongwen, it will still be faced with the task of determining whether, considering the poor background provided by the secondary evidence, Mr. Ongwen is genuinely reporting to Joseph Kony or just taking credit for the acts of another person so as to win Joseph Kony's favor. Note must be taken of the inaudible voices in the background of those intercepts. Was the person alleged to be Dominic Ongwen talking without being prompted to do so by the voices in the background? Number two, whether the statement attributed to Dr. Ongwen was consistent with what had been taken place in the crime base, especially when he stated to have killed all the people in Udek camp, although the facts on the record given by the government seems to suggest that only about 60 out of 60,000 people, or 6,000 people in the camp died in the attack. Number three, Your Honors will have to answer the question whether the statement was consistent with someone not suffering from a mental disease or defect born out of fear for his life. Mr. President and Your Honors, defense will challenge the storage and the chain of custody of the exhibits. Those who were in charge of intercepting, recording, and storage of the exhibits clearly told court that their place was damp. The tapes were rubbed and reused many times over. In addition, there was always a serious destructive conflict and rivalry between the personnel of the different security agencies who were housed in the single building in Gulu. It cannot be ruled out, Mr. President, and your honors, that these affected the integrity of the records. It will be shown that those recordings were not only improperly kept, but they were susceptible to human interference, especially by the UPDF, who played a role in the charged atrocities. In addition, court has to be reminded that there is evidence on court record that the accused was an enigma to and a thorn in the flesh of the UPDF, and therefore they have a motive to fix him. The prosecution will draw the attention to the prosecution's, the defense will draw the attention to the prosecution's own admission that the exhibits were not beyond reproach, Mr. Gumpert said. The collected material was intercepted and recorded, sound recorded with rudimentary equipment over 10 years ago, and it was done in the context of an armed conflict. That too hampered the ability of the radio operators to intercept and record all of the LRA communications. Recording wasn't always meticulous. Sometimes labels fell off the sound recordings. And at one time, the ISO's archive was affected by damp. Sometimes communications recorded in one logbook are not reflected in another, or can't be discerned in the corresponding sound recordings. Mr. President and your honors, defense will show that logbooks, which the prosecution heavily relies on, are the most unreliable ones. Reason being that they were most susceptible to human interference. In the instant case, according to the prosecution evidence, the logbooks and the cassette tapes from all the security agencies ended up at the hands of prosecution witness number 38 at the chieftaincy of military intelligence. Prosecution P38's evidence of how the records were kept in his office for more than 10 years also leaves a lot to be desired. He testified that he had to spend a considerable amount of time sorting out what he thought was relevant for the prosecution case from a huge heap. Mr. President and your honors, prosecution presented before you what they called enhanced audios. You will, however, be reminded, your honors, that the defense demonstrated in cross-examination where an enhanced audio was used for attribution, that it was possible for the OTP audio enhancers to alter the character of the voice and possibly even content, making it unreliable. Mr. President and your honors, the defense will show that authentication is the best requirement when dealing with audio evidence in a court case. Much as the defense would agree with the prosecution's assertion that intercepts are the most important evidence the chamber will hear during the trial, we do not agree that the court will find the intercept evidence particularly valuable because it is unaffected by human memory's fallibility, and it is free of bias or the suspect's motivations that can taint witness testimony. And further, that they are an accurate record of the LRA plans and operations. The defense will raise issues with the authenticity of the intercepts. It will be shown, your honors, that it will not be lost on you that despite leading evidence through Mr. Laroche and Mr. French, the purported originals are actually copies of tapes The OTP did not call an expert to authenticate them. The prosecution has not brought an expert in audio attribution before you. They have not even sought leave to authenticate the tapes which the defense argues that the logbooks established Dominic Ongwen's role at Pajule, even though there is no audio intercept from him there. Given evidence that the tapes provided were either in fact altered, it is certainly curious that there is no audio provided that shows Mr. Ongwen was present. Mr. President and Your Honors, court record elicited by prosecution shows that from testimonies elicited by prosecution shows that the competent intelligence services and the Joint Intelligence Committee at the CMI in Kampala conducted a critical analysis of all the intercepts in their natural and original forms in which they were submitted. They examined and confronted them with the contemporaneous reports that accompanied the intercepts. They verified other sources of intelligence, including counterintelligence, and through directional findings, determined the location of the respective LRA commanders during the charged attacks. And evidence shall be provided by way of the directional findings provided by the government of Uganda that Dominic Ongwen was nowhere within the vicinity of the charged crimes. Your Honors, the defense case is that the first line of defense case is that the charges brought against Dominic Ongwen has already been indicated, indeed against the LRA as an institution and not against Dominic Ongwen. Secondly, the defense will show that Dominic Ongwen did not personally participate in the charged crimes. Thirdly, the defense will show that Dominic Ongwen had no command responsibility for the charged crimes. Neither did he have any role in the planning and execution of the charged attacks. Fourthly, the accused will plead affirmative defenses provided under under Article 31 of the Rome Statute, that is mental disease or defect. Last but by no least, and closely linked to the affirmative defenses, the accused will plead, but only in the alternative, the defense of duress. It did not have a mind of his own, and it will be assiduously argued that the conventional understanding of the principle of being under immediate danger, apprehension of immediate danger, does not hold good in a spiritual world, where Joseph Kony, though not physically around hovering a gun over Dominic Ongwen, was perceived to be around anyway, in spirit. Your Honors shall be reminded that prosecution totally failed to show that there was any ballistic analysis of the ammunitions that killed the victims. We have already talked about that. Um, Your Honors, when we talk about mental disease, as has already been suggested, Professor Moreno Campo, the inaugural chief prosecutor of this court, is on record as having said, Kony is abducting children and transforming them into monsters. By this, he was talking about nothing but the impact of LRA indoctrination and the coercive environment in which the abducted children grow up, which made them monsters. By definition, a monster in the context of this case, Your Honors, is a devil or demon. Mr. Moreno Ocampo was spot on. Your Honors, I know that time is running against me, and I shall leave the others to my colleagues. But before I leave the stage, I want to, in conclusion, remind the court about what is important to consider when you come to the question of duress. The most pertinent issue you must resolve, and we propose very strongly that you should resolve it in favor of the accused. What was the impact of indoctrination, of spiritualism, of the coercive environment, of the injuries, of everything that happened to Dominic Ongwen in 27 years? What was the impact on his mind? And in particular, we indulge you to consider the conditions of multiple injuries Ongwen sustained around the charge periods when he was limping, and he's still limping. What did it impact on his mind? Could any child under those conditions have been put in a state where he lost his mind, he was under apprehension of danger all the time, and therefore did what he did not intend to do? Did he act if, and of course we say he did not. In case you find that he did what is supposed to have, he is alleged to have done, the question is, did he form the intention? Did he have the mind, the presence of mind to do it? And in conclusion, Mr. President and Your Honor, the court, we have laid the ground, the context of this case is predicated on the character of the state of Uganda and the things that are very likely to be done by the government forces. Mr. President, the court will be reminded also that the recent European Parliament resolution, which resonates the overwhelming expression of American public opinion about what happened during the by-election in Arua, will vindicate the defense that the state was prone to attacking the civilians in Acholi land. The leadership of Uganda is now reinventing the wheel and this is not the first time he has done it, to give the English dictionary a new meaning of torture. According to him, killing and beating some opposition leaders is not torture, although some of them are lying prostrate in hospitals around the world. This attitude is not new to Ugandans. We invite court to take judicial notice of that trait in the character of the state. I rest my case, Your Honor.
Thank you, Mr. Ayena. Mr. Taku, you have the floor.
Well, Your Honors, with all humility, when one listens to the brilliant eloquence of my learned colleague, Honorable Ayena, and I'm given the charge to get up to continue from where you left, I can bear to say that I know I have quite a job to do. But he had laid the groundwork. He had laid an overview of the case. I will focus on the case, and where need be, even if I raise some of the issues, I will direct you to the evidence. I will make strong statements, but each of them will be substantiated, lest I'm misinterpreted. Your Honors, Your Honor will remember that on the 6th of December 2016, we called on Mr. Ongwen to plead to an abridged statement of facts in the charges confirmed against him. He provided the following answer. Quote, "This is a decision of life and death. In my opinion, this amounts to my going back into the bush for a second time. The International Criminal Court, do you agree that I am the leader of the LRA? Do you agree that my life was not ruined?" End of quote. When Your Honor, the Honorable President asked him, "Do you make an admission of guilt with any charge?" Mr. Ongwen again answered, "In the name of God, I deny all these charges in respect to the war in northern Uganda." End of quote. By these statements, Mr. Ongwen clearly stated in clear and unequivocal terms that he understood the abridged statement of facts that was read out to him in court to mean that he was committed to trial for crimes committed by Joseph Kony and the LRA in the conflict in northern Uganda. Your Honor, Joseph Kony is not here in this courtroom standing trial, but Dominic Ongwen is here, treated as his substitute. The prosecution indeed intended Dominic Ongwen to be the clone of Joseph Kony in this case. Your Honors, contrary to the prosecution's assertion in an opening statement on the 6th of December 2016 that, and I quote, "The trial is not about the LRA's culpability for its crimes, but about one person, Dominic Ongwen," end of quote. The evidence will show that this case is about Dominic Ongwen being held accountable for the crimes against Joseph Kony and the LRA. If the prosecution's statement was true about the LRA and Joseph Kony, then the prosecution should be prosecuting Joseph Kony, its founder and leader. And Joseph Kony should be sitting in the dock, not Dominic Ongwen. But Joseph Kony, indeed, is not in this courtroom. Dominic Ongwen himself, a victim, a child soldier, forced into service by the LRA, and Joseph Kony ought not to have been charged and asked to defend himself and regard whether he is responsible for actions taken on the orders of Joseph Kony. The confirmed charges and the prosecution evidence led, in this case, seek to present Mr. Ongwen as an appropriate substitute, symbol, caricature, ghost, or phantom of the absent Joseph Kony, whose absence from this courtroom is tangible. The confirmed charges allege that Mr. Ongwen, Joseph Kony, and some other commanders, named and unnamed, conceived plans to commit the crimes for which Mr. Ongwen stands trial. The prosecution considered that the charges it brought were a collage of charges it was not bringing against others. In a footnote 13, in filing 1,110 of a legal document, the prosecution stated, and I quote, the 70 offenses charged by the prosecution represent a selection of crimes that were investigated and considered in the situation in Uganda, end of quote. The charges and modes of liability alleged are a serious indictment of all child soldier victims who faced Mr. Ongwen's predicament but were not charged. The charges and the allegations are a critical indictment of the very conscience of humanity that this court was established to protect. Your Honors, Mr. Ongwen totally respects all the victims of the conflict in northern Uganda and all child victims adopted or associated with brutal armed conflict all over the world. And he wants me to make that very clear before your honors. Many testified, and many more will be testifying, how Mr. Ongwen put his life in danger to protect them. The evidence will be led to demonstrate that Mr. Ongwen is strongly asserting his right to occupy his rightful place among the victims of the atrocious crimes that destroyed, shattered, and devastated his childhood and that of victims in northern Uganda. Some victims came here to tell their story. Many more victims will be called by Mr. Ongwen to tell their own stories. Whether called by the prosecution, by victims' counsel, or by the defense, they all have a unique characteristic and a common story to tell. The story was considered in part by the prosecution in her opening statement that the area structure and the roles that were responsible for the victimhood of the victims and Mr. Ongwen were conceived, established, superintended, commanded, and controlled entirely by Joseph Kony and his legion of spirit, to whom brainwashed adoptees and victims owe unquestioned loyalty under the penalty of death. The victims that the defense will call to testify, like my learned colleague has said, those victims, like those victims who have testified before, were identified Joseph Kony and the ARA, not Dominic Ongwen, as the orchestrator of the victimhood. With the prosecution of Dominic Ongwen, therefore, the soul of the individual and collective humanity is on trial in this courtroom. Dominic Ongwen should be sitting on the bench of potential witnesses awaiting the potential prosecution of Joseph Kony and senior UPDF perpetrators, if that will ever happen. He should not be sitting here answering 70 charges, as Lynette, Honorable Ayana has submitted. The evil will establish that the present trial potentially supplants and sanitizes the crimes perpetrated by ARA, Joseph Kony, and the UPDF in northern Uganda against northern Uganda victims, among whom is Dominic Ongwen. On the 6th of December 2016, the prosecutor commenced the prosecution case by defining Joseph Kony and by defining Dominic Ongwen. About Joseph Kony, the prosecutor said of the ARA, discipline was strict and punishment for infraction of the rules were brutal. Attempts to escape were particularly harshly dealt with. Those who were caught were either put to death or caned so severely that permanent injury was often caused, end of quote. The prosecutor, in her opening statement, cited one occasion when Joseph Kony and his deputy, Vincent Oti, boasted about their actions with sadistic arrogance over Radio Mega FM. Quote, Joseph Kony viewed children as easily molded into the ruthless fighters that he needed to continue his policy of murder and persecution, end of quote. But then, this is only an incomplete picture of whom Joseph Kony is. The defense will complete, will bring more in order to show whom Joseph Kony was. The defense will present a complete picture of his command, control, and cohesive violent power struggle established by Joseph Kony. The evidence will show that Joseph Kony and Joseph Kony alone used this structure to impose the misery, which the prosecutor in an opening statement alleged, quote, blighted the lives of millions of people living in northern Uganda. Ordinary citizens, civilians who wanted no more than be allowed to live their lives in peace, could no longer live in the villages in which they were born or raised. Violent attacks on civilian targets by an armed group calling itself the Lord's Resistance Army, ORA, had resulted in those ordinary people being forced into the camps for internally displaced persons and often reduced to dependency on international food aid. These camps were themselves subject to railway and telephone attack, end of quote. Joseph Kony and Joseph Kony himself created and owned and superintended and commanded this network. The prosecutors should be looking for him and not Governor Ongwen, the victim. The evidence will show that Joseph Kony had an elaborate modern radio communication technology network, which he used to exert control and command over all operations ordered, supervised, and implemented by him. No matter his physical location, he relied on this radio communication technology to oversee the effective execution of his orders and to personally participate as the ultimate supreme commander in the supervision of the execution of his orders. The prosecution effectively considered this in its opening statement that, quote, the radio was used to exert pressure upon commanders. The transcript of 26, page 42, lines 16 to 25, T26, page 45, lines 4 to 18. The evidence will show that Joseph Kony deployed trained intelligence officers and trained signalers.
Mr. Taku, I'm reminded by the booth that you perhaps should be a little bit slowed down.
Okay, all right, thank you.
Yes, thank you.
The evidence will show that Joseph Kony deployed trained intelligence officers and trained signalers who reported directly to the Director of Intelligence and the Director of Radio Communications, who were at the control altar under the direct command of Vincent Oti and Joseph Kony. These signalers and intelligence officers provided constant information about the units to which they were deployed and the activities of their commanders. The evidence will show that Joseph Kony imposed elaborate rituals, as Leonard Honorable Iana has submitted, and spiritual interventions that were performed by special commanders from the yacht deployed to all units of the ARA. The evidence will establish that Joseph Kony kept elaborate records of all the events that occur within ARA, including the numbers and names of women in the ARA, the number of sick persons in the sick base, the record of food in stock and distributed to different units. The evidence will show that apart from the rules, Joseph Kony established a vast power and control network, which he used to keep surveillance and exerted additional absolute power, influence, authority, control, and command over Dominic Ongwen and LRA. Some witnesses who have testified, Your Honors, in this case were double status informants for Joseph Kony and the UPDF. Your Honor, the single judge in your decision, paragraph 8, filing 1234-20 of 20 April 2018, agreed with the defense filing ICC 02-4-01-15-1229 at paragraph 13 that other individuals with a similar background have provided testimony in the present case following disclosure of the identities to the defense. This occurred when the government of Uganda objected to the disclosure of the identity of a double informant whom it stated was a Lord's Resistance Army civilian collaborator with very close contacts with Joseph Kony, who informed the RAA of UPDF movements until he was persuaded to switch sides, and become an informant for the UPDF, filing 1217, Annex 5 April 2018. The evidence will show that the Mega FM radio interview by Mr. Joseph Kony and OT was not an isolated tool. Joseph Kony's extensive and elaborate control and command arsenal, which he controlled, directed, manipulated, and dominated the worldview and mind of Mr. Ongwen and every other person who came within his reach. Joseph Kony had extensive contacts with foreign governments, among them the government of Sudan, politicians and informants within the UPDF, and government of Uganda, who sustained his personal survival and the RA. Some of the RA prosecution witnesses were senior commanders who testified that life in the RA was tightly controlled by the rules and the spirit. P440, that the Honorable Ayena talked about, was a senior commander. He was senior to Domino Ongwen by his command position and control altar and his proximity to Joseph Kony during the charge period. He and other area commanders who testified provided evidence of the tight command and control that Joseph Kony and the spirit exerted on every aspect of individual and collective life of the ARA. The spirit and Joseph Kony revealed future events in the present. They read the thoughts of individuals. They made their punishment for infractions and rules. Kony developed a command and control operational strategy that did not deploy soldiers from a single unit to conduct an operation. Rank was not a consideration for him to decide who would lead an operation. One senior commander recorded a statement that is UG OTP 0283-2035 and UG OTP 0283-1616 at 1619, and I quote, despite the fact that we had 4 brigades, we could sometimes pull manpower from the various brigades to go for a joint operation under the command of one person who could be chosen by the higher command, end of quote. So the person chosen is chosen by the higher command. He doesn't plan the operations, he's choosing with other units so that they could control each other. See? The spirit had absolute power over promotions, with Joseph Kony acting as the spirit medium. Joseph Kony and the spirit determined and ordered all operations, ordered adoptions, wife distributions, punishments. They held absolute power of life and death over every area combatant. The following officers were mercilessly executed. Vincent Oti and Oti Lagoni, who were Kony's deputies at different times, were among the many executed. Joseph Kony executed his own chief of security and wing for the rape of his own wife. The wife reported to Joseph Kony that the husband had raped her. Or the prosecutor uses the word conjugal unions, so as to use conjugal unions, because that's what is the confirmation edition. And Joseph Kony was zero tolerance for sexual offenses, executed his own chief of security and wing. He imprisoned and ordered that Dominic Ongwen be executed shortly before Ongwen escaped and surrendered in Central African Republic. The prosecutor promised during her opening statement to refer only in a very limited way to some area commanders during the trial. With Dominic Ongwen at trial, the evidence will show that the prosecution placed responsibility for alleged crimes which were committed by Joseph Kony and some of these commanders, whom the prosecutor said they will mention them only in a limited manner. With Dominic Ongwen here, the prosecutor now decides we will not mention them at all, only very limited information about them, even though in the form of criminal liability, Dominic's alleged to have planned the attacks with them. Now, as Honorable Ayana said, Surprisingly, with Governor Ongwen, the charges against him skyrocketed to 70. Why this against Connie remained at 7? And therefore, we are right to say that this trial intended to sanitize Joseph Kony, to make him look like a saint, look like a subordinate to Ongwen. Ongwen was everything, Ongwen committed all the crimes. There's no need to look again for Joseph Kony. 70 counts against Ongwen will solve the problem. Now, Your Honors, to realize, okay, because the prosecutor had promised that they will not leak a lot of information against some of these commanders, very little, if at all, a lot of exculpatory evidence have been withheld from Mr. Ongwen. Evidence that will relate to people who are mentioned in the form of criminal liability, are co-perpetrators or who perpetrate Ongwen at different times, is withheld. The character of the conflict during the charge period, for example, reports the evidence we will produce, Your Honor, is UGA OTP 0025-0257, UGA OTP 0025-0205 is showing that the evidence will show the delivery of weapons and arms from Sudan, including during the charge period, making this conflict an international arms conflict, as opposed to the internal arms conflict that the prosecutor allegedly and was confirmed, the charges. The evidence, Your Honors, from some of the victims themselves. The prosecutor brought evidence about the Luala attacks, trying to place Ongwen in Teso during these attacks. But the evidence from the victims themselves, and some of them, one of them identified the attackers. And this evidence also from the UPDF itself. UPDF also has a list of the girls who were adopted and the commanders. And they identify one Okelo Kapari as the one who led the attack, not Governor Ongwen. UGA 0206-0090, UGA 0206-0091. The prosecution had this evidence in custody, Your Honors, during the prosecution's case, including the statements identifying Okelo Kapari and Tabule as the commanders who led the attack and adopted those guys. In spite of this evidence, overwhelming evidence, the prosecutor did not do what should be done in the of justice, so absorb the charges with regard to the Luala attack against Ongwen with overwhelming evidence, including their own evidence and the evidence from the victims. No, they leave the charges and withhold most of the evidence. Joseph Kony is a central issue in this case. Whether it's here or not, the ghost of Joseph Kony is controlling this case. It's right here in the courtroom. And it's the ghost and the shadow of Joseph Kony, and of course that of the senior commanders of UPDF, that are an issue in this case. The prosecution mentioned that we do not have any body of proof whatsoever, and we could have stopped at that. But then, apart from the question of proving the case for purpose of completeness, we believe that it's our duty and the duty of all participants in this case to bring the complete picture to Your Honors so that justice can be done to the people of Northern Uganda. One of the purposes of a criminal trial is for the historical record. So if evidence is withheld, it causes prejudice. It defeats the aims of justice. And therefore, the defense, although we have no body, but we'll try to bring as much evidence so disprove the prosecution's case. Your Honors, you will know that if evidence is withheld, the prosecutor submitted about these commanders, the evidence relating to the charges is incomplete. Dominic Ongwen, in this case, it must be understood, is not charged as committing the crimes alone. But Dominic Ongwen is being held responsible for crimes of individuals who have not been charged and some who have been granted amnesty. And the question we ask on us, Kerr, is this. The prosecutor's investigation obligations to investigate incorporated and exculpatory evidence extend to getting the evidence about this individual honesty, not for the purpose of charging them, but for the purposes of determining their contribution to the crimes for which Ongwen stands charged before this court. And the reason, Your Honors, for this is this. Without that evidence about those commanders, those individuals mentioned in the charge, Your Honor will not be able to ascertain the extent of the contributions of Mr. Ongwen. The spotlight is on Ongwen and Ongwen alone, who found him. Even the evidence about Joseph Okonie, the prosecutor has clearly suppressed it. And the government of Uganda, when I will come to the government of Uganda, when I start talking about the question of the investigation in this case. And therefore, Your Honors, we will bring evidence from senior commanders who were proximate to Okonie, including the founding commanders, who were with Joseph Kony, when Kony defined the rules regarding to women, regarding to children, who were present. They were educated. Some of them were members of the Ugandan army. We will bring the evidence from them and submit, Your Honors, because it was important for you to know exactly, not from other people's narratives, but from the narrative of those who established the rules. The prosecutor, as we heard it, the recorded statement may refuse to call, who will bring the evidence, nevertheless, back into the record and before Your Honors. Now, Your Honors, another problem we'll bring to your attention is that, and this is flowing from the question of the informant. And you remember the reason the government of Uganda gave was, it was for the protection of their informants, or the ability to gather intelligence in the future, or the safety of their informant. But for the purposes of understanding the power of Joseph Kony, the government of Uganda declared that Joseph Kony had been defeated, the war ended, and they stopped military operations. But if the government of Uganda can fear the shadow of Joseph Kony, even in defeat, to the extent of saying, no, we will not expose the identity of our informants, it can fear even in defeat. What about Dominic Ongwen, the child soldier, whom even from the injuries that you saw here, from November 2002 to a time period early, maybe March 2004, he was in the hospital, in the sick bay. And this brings me to one point, because I listened to the experts that the prosecution brought here and some of the victim testimony, and it does appear that everybody in northern Uganda is afflicted by one form of trauma or mental defect. Everyone. But strange enough, according to their theory, apart from Dominic Ongwen, how can they explain that Dominic Ongwen alone? Even from the mere injury he sustained, that was in the sick bay, the mere trauma of encounter with Joseph Kony, break. Yeah. So even from that injury alone that you saw, that has incapacitated him, just from that. The trauma alone on that attack, the circumstances alone, how come it, by what miracle, can Dominic Ongwen be the only victim, child victim for that matter, who does not suffer from the prosecution's expert at their testimony from mental defect, when people who were tangibly, who were not even in battlefront, the chain affected them in different forms. Your Honor, my colleague was telling me we have just 1 minute, and I do not know for break. Is it break?
I think we could, if
I
it,
can continue.
yeah, no, I think we can stop here. But if you want to simply finish your line of thoughts on this
1
topic,
o'clock, Your Honor.
yes,
Okay.
yeah, please continue, but then we can have a
Your
break.
Honor, yes. I'm moving very fast. We'll
Yeah.
leave more time for my friend.
Okay.
But at 1 o'clock, yes.
Yeah, okay. So then we have the lunch break now.
Yes, Your Honor,
Yeah,
thank you.
until 2:30.
All rise. We will obey.